This week on the Communicators, a discussion about telecom and technology policy with three former chairmen of the Federal Communications Commission. Our guests are Hundt, Michael Powell, and Kevin Martin.
This is the Communicators program, and we're pleased to welcome three previous chairmen of the Federal Communications Commission to a discussion on telecommunications policy. Here's who's joining us today. First off, Michael Powell, who served as chairman of the FCC from 2001 to 2005. Hundt served under President Bill Clinton from 1993 to 1997. And finally, Kevin Martin is the most recent former FCC chairman, 2005 to 2009. Gentlemen, thank you for being with us today on the Communicators. Amy Schatz of the Wall Street Journal is our guest reporter. If we could, let's start with a question for all three of you. And we'll start with you, Mr. Hundt. There's been a lot of talk in Congress and in the FCC and among interest groups about revamping some of the 20th century telecommunications laws for a 21st century world. And I want to get your views on whether or not you think, number one, is the FCC regulatory model capable of managing the current telecommunications world? And if you could, how would you revamp the current telecommunications laws?
And this would be a 1 hour question? So, is the FCC capable? Absolutely. One thing that I think we should all agree on, I suspect we all will agree on, is that under Chairman Martin and under Chairman Powell and under really all the other chairmen, this agency has continued to have a lot of expertise, a lot of integrity. It has not been plagued by scandal. It is not a place where you go and see stories of incompetence. It actually is an example of a government that works. It is a model that we as a country would love to see in other countries. We would like to see independent regulators. We would like to see expert regulators who are more independent of a political process. And we'd like to see that all around the world. So I think it's a very good model. That doesn't mean that we ought to regulate everything that moves or every bit of the internet, but it does mean that the American people, when they look at the FCC under Republicans or Democrats, are basically looking at an agency that works. Number two, should we have 21st century regulation in the 21st century? Well, yeah, it makes sense to keep up with the times. What are the major issues that therefore have to be dealt with that are relevant to the next 10 or 20 years? Number one, we have to have a way to get more spectrum from places where it's unused or not used in an adequate manner into the private sector, because spectrum is the platform for the development of a wireless industry, and that's where we're going to be going for job growth and productivity gains. That's a very, very, very important topic. Number two, we need to have certainty for industries about the future of regulation so that American companies that want to invest understand how to make calculations about profitability. Fact number one, American corporations are sitting on unused cash at a record amount. Fact number two, we have a terrible, terrible problem with unemployment. You add these two things together, we need to have the opportunities for investment be clear so that the American corporations can take the cash out of the tiller, put it to work in the market, and create jobs.
Mr. Martin.
I think the commission has the tools it needs to continue to regulate, but certainly legislation would help. I mean, and I think that, I give Michael credit. He's been calling for that certainly since he became chairman. I remember early on he was talking about the need for Congress to try to, revamp the legislation to give us more tools to try to deal with the convergence that was occurring across platforms. So I think that the commission has the tools so that they continue to do what's necessary, but I think they'd be helped by additional legislation.
And what would you like to see done?
Well, I think that the most important part of that legislation is trying to find a way to create a more level playing field as the traditional silo approach that the current Communications Act has put into place has been evaporated by the increasing use of IP technology, which allows all the platforms to compete against each other. You've got to take that into account in a new regime, and I think that would be important for them to do.
Chairman Powell?
Yeah, I think Kevin's touching on it. If you look back at the last decade at the FCC, you'll see a competent agency, but one that spends its entire life in court. And there's a reason it's spending its entire life in court. It's administering a statute that's increasingly ambiguous when applied to the reality of technology-driven markets. Increasingly, we have a statute that's balkanized into these buckets built around both technologies and economic models that predate the internet. If you use twisted copper wire to provide a one-way voice service, you're a telecommunications service provider and you live in this bucket. And if you provide cable services, you live in this bucket. But as we all know, the rise of IP, as you referenced, and the rise of a bit is a bit world means distinguishing between communication services premised on pre-internet technologies is a formula for complete confusion and uncertainty. And the reality is Verizon may be a phone company, but it competes directly with Comcast for video services, and Comcast competes directly with other companies for telephone service. So increasingly, I just feel like we have a statute that is now a constant source of gray, that does not provide the kind of clarity necessary to deal with the technology we're seeing, and one that's relatively sort of mucky in that it's a very slow process against a market that moves really, really fast. And then the last thing I would say is there's a whole new crop of powerful companies that are probably as significant or more significant in driving communication than the traditional carriers. I mean, you can't talk about communication more and you're not going to talk about Google, and you're not going to talk about Facebook, you're not going to talk about Microsoft or Cisco, or and yet in some significant ways they live in a world completely outside this conversation on the periphery. And I just think at some point that has to be brought together in a more coherent way.
How is it that they live outside the conversation?
I would say that they like to live outside the conversation in that they haven't been regulated by the FCC in many ways, but the companies Michael is talking about have spent a lot of time talking to all FCC chairs about the way the FCC ought to shape the platform that makes over-the-top companies succeed. So the Facebooks, the Googles, the Yahoos, all these companies exist on a physical network, on a platform that in fact is regulated by the FCC. The shape of that regulation is very important to their business prospects. So I think that the part where we're agreeing is you need to bring all the firms, the beneficiaries and the network providers into the same conversation and need to strike a reasonable balance, because without enough money to build the networks, you don't have robust enough networks for these firms to thrive on top of them.
And that kind of goes to Chairman Martin's silo argument, doesn't it?
Yeah, no, I mean, I think that what I was really talking about, though, was the different platforms are regulated, the different technologies are regulated in different ways, and there are some of the services that go over the top there are some regulations that apply, things like 911 when you're providing a voice service, regardless of what kind of technology you're using. So there are instances in which the Commission has been able to, but I think that it would certainly be aided by Congress trying to address that in a more systematic fashion.
You know, the problem is when you talk about Google and these other companies, what you have fundamentally that's askew is we're regulating based on who you are and where you came from, not what you're doing. And you know, increasingly to a 19-year-old who's grown up digital, who's having a phone conversation over Skype, there is no significant meaning between the difference of doing that on their cell phone or doing that on their landline phone. But it makes a huge regulatory difference, and there's very different cost consequences and structures for those companies because they're labeled this rather than that. I've always say to my neighbors, I challenge you to go ask your kids to name the broadcast networks. I don't think my children have any idea that Channel 7 is different than Channel 107. But yet, the First Amendment changes from Channel 7 to 107. Regulatory treatment changes radically from Channel 7 to 107. One's a cable channel, one's a broadcast channel. And yet, we're still administering this statute that goes through this pretense that these things are sort of clearly defined categories. And I think that can't be sustained for very much longer.
So next year, when Congress comes back, depending on what happens with Congress this fall, it's very likely they're going to look at doing some sort of telecom rewrite, and it's not entirely clear if it's going to be very narrow, focused on net neutrality, or if it could be a broader rewrite. Would you all agree that maybe they just need to take a look very broadly at just rewriting this entire statute so that you don't have these kind of silos in the future?
I would say this: it depends on what problem Congress is trying to solve. The 1996 Telecom Act was meant to remove barriers that kept businesses from competing with each other. That was the whole idea of it. The modified final judgment had said to the bell companies, you can't go into these adjacent markets. and the long-distance industry had no way to go into the local market. There were a variety of other examples, but the fundamental premise was, let's remove the barriers and let the industries invest in each other's markets, and all of that new investment will produce technological change, and it'll produce innovation, and it'll produce job growth. What happened? Well, the law wasn't the only reason that the following happened, but it's a contributing factor. 2.1 million new jobs were created in and around the ICT sector in just the succeeding 5 years. $850 billion was invested in networks in the United States from 1997 to 2007, the 10 years that followed that law. These are great success stories. Of all of the extra revenue that led to President Clinton balancing the budget, 1/3 of the extra revenue that was outside the models came from growth in the ICT sector. It's a great story. If Congress wants to rewrite the Communications Law of 1996 to drive investment, that's really terrific. If they want to do it to pursue an ideological agenda of some kind, if they want to do it to entrench monopoly, then that's a bad thesis. So it all depends on what problem Congress is trying to solve.
But, just to jump in, because Reed says something that I think most people forget, the real reason for the 1996 Act was the unraveling of the 1984 antitrust suit against AT&T, and it really was about competition between long distance and local companies. But what's interesting today is there's no such thing as long distance. No one in my house makes any distinction between calling long distance or local like we once did. The cell phone industry largely crushed that as a separate category, but yet the fundamental organic statute still has these mechanics that are all about, this competition that I don't think is necessary.
But isn't this a really, really big point? The long-distance companies wanted the 96 law changed so that they could go into local. The local companies wanted it changed so that they could go into long-distance. The over-the-top companies, Google, Facebook, etc., they don't want to go into the service provider business. The service providers don't have the skill sets or the focus to want to be another Google. So we don't have the same let's fight each other tension that made the 1996 Act a pro-investment act. What would be the purpose of a new law? Would it be to cut a better deal for the content companies relative to the networks, or would it be to cut a better deal for the networks relative to the content companies? When Congress gets into the business of saying, I'd like to take some money from your pocket and put it into that guy's pocket, that's not a pro-jobs, pro-investment agenda. That's a kind of log rolling that is not very pretty to watch and is not what I think you would want to see the next Congress start doing.
Go ahead. Yeah. No, I think it's a fair point, though. I would say that the corpus of issues around the internet from a regulatory standpoint now are much broader and more intriguing than traditional telecom policy, right? I would say that we have serious issues of intellectual property and copyright. There's a never-ending tension about what privacy means up against a set of companies collecting a scary amount of data to provide targeted advertising to me as a consumer. Right. There's a whole, and then there's things like around net neutrality, which I think one of the reasons it's such an intensely fought battle is it is exactly this fundamental tension. Should AT&T be allowed to be a competitor to Google, or must it simply be a transport vehicle for Google services? I have no problem understanding why Google might prefer the latter. I also have no trouble understanding why AT&T might be contemplating the former. But at the end of the day, nobody knows the answer to that. And that uncertainty, I think, creates a stall in the market.
But Mike, there's no law that says those companies are blocked from taking those actions. Those are strategic decisions that no law denies them.
Except a strong net neutrality might.
But there's no existing law that needs to be changed.
Well, I think that there are some examples where they actually are competing more directly, not only when they're providing, over-the-top providers are providing voice services that they compete, over-the-top providers are increasingly providing video services that they can end up competing. So those are examples. There's others on the margins. For example, Google has replaces a lot of its servers on the remote edges of the network to increase the speeds with which they do that. That has implications for the network operators who have similar kind of business models where they want to provide that service on a wholesale basis that was implicated by the net neutrality rulemaking that they started. So there are examples, I think, where this is happening.
I agree with that. Let's take Skype, for example. There's some talk in some circles, I'm sure you've heard this, that the Skype service maybe should be regulated on a state level. Right? None of us think that's a good idea. This is a fundamentally a boundaryless medium that we're talking about, the data networks of the world, and for Skype to utilize data networks to provide something that sounds like voice doesn't mean that they ought to be regulated on the state level as if they were part of the 19th century.
And I think the clarity Congress could provide on some of those issues would be helpful. But
Although the FCC can solve that one, right?
But I do agree with you that anything Congress should be doing, particularly in this environment, should be very conscious of pro-jobs, pro-growth, pro-investment. I mean,
Let's assume then that Congress doesn't do anything this year, which is a fairly safe assumption. It's very hard. Well, not this year, next year. It's a fairly hard thing to get telecom rules through Congress.
Well, you just said, and I think you're right, they will initiate legislation in the
initiating
different
is different than
but people
finishing legislation. But
have
if you
views.
assume that they don't finish legislation next year, what can the FCC do to move forward? Right now, they've talked about going back to Title II. Should they go back to Title II? Do they have other options to give themselves the authority on net neutrality and the other things that they feel like they need to do?
Now, you caused this problem.
It's all your fault, Kevin.
So I feel that you should explain how the jurisdictional thing has all come about and how it'll get resolved.
Well, first of all, Chairman Martin, did you cause this problem?
You know what? I get blamed for causing lots of problems.
Okay.
Yeah, so that's not an
No, but
unusual
but I'm not. I don't. I'm sort of teasing, but I'm also saying it all comes out of the case, right?
Well, out of the case and out of the Commission's decisions where they were classifying, how they were classifying broadband services. I think one of the things that's most striking about the debate and about the reclassification proposal, the so-called third way, when Chairman Janikowski put it forward, was his hearkening back to actually the relative balance that he thinks the Commission had tried to achieve between investment and trying to protect consumers for the over-the-top services. I mean, I think that what he was actually, while I may not agree with the reclassification proposal, what I think was most interesting is what he was saying is, I'm just trying to restore the balanced approach that I think the Commission has done. So he explicitly rejected kind of some of the wholesale obligations, unbundling obligations that might have gone along with that. He explicitly talked about the fact that it should be very case by case and very specific. These were all decisions that at the time seemed very controversial, but actually are very now embraced and almost more widely accepted. So I think that the approach that everyone seems to be gravitating towards is just trying to continue on the path on that issue that I think the Commission had tried to establish. And I think that actually does signal at least the direction in which they should end up going.
But here's what's critical. I mean, the chairman does say that, right? And I happen to subscribe to it. Reed and I were talking in the green room that, look, when we first introduced network neutrality principles, first by me, taken to another level by Kevin, they reached, I would argue, they reached a relatively stable consensus, both in the market and among advocates. And suddenly the hornet's nest's gotten shaken up again, and so the notion of returning to that kind of stability is a good one. But we shouldn't act like if you reclassify, you're going back to what existed before. That is a radical departure from the way it was before. These companies for a decade almost a decade, have proceeded under the regulatory assumption that they're a particular classification. Their business models, their investments are premised on that. I mean, reclassification completely turns that back, and it's dependent on how successful they are on the second half of that shoe, which is, can you forbear from all the regulations that would immediately apply to these carriers? And, you know, like you're pointing out, there's a lot of nasty stuff hiding in the world of Title II that you'd have to be confident will get whacked through and that courts will accept, and everything from pricing regulation to wholesale regulation. So I think it's messy. But I want to say something, Amy, that I think is really important. The FCC is not the Congress. It's a regulatory agency, and any power it only has by the grace of delegated authority from the Congress. I fundamentally reject this suggestion that, if you don't have authority, or there's some serious question of your authority, and Congress is clumsy and slow or broken and can't do it, you're supposed to go find a way to create your own jurisdiction and act because they won't. That is anti-constitutional, if you ask my opinion. I mean, if there is a very serious question whether the agency has the power it needs to do something, by the way, I think there is way more consensus about than the noise would suggest. I don't think the substance of net neutrality is very hard at all. It's all about how you operationalize it in some regulatory form. And I just think that at some point you have to say, this is Congress's responsibility They're the ones who have to take this. No one should let them off the hook, and no one should say, well, it's hard, it'll take a while, so let's not do it. Let's run off and do it at the agency level, because if you really look at a series of court cases, and Reed's had them, Kevin's had them, and I've had them, where court just, if there's a kind of case where you will get massacred, it's when the judiciary believes what you're really doing is accreting power to yourself that the legislature never gave you, and those are the nastiest, most vicious opinions that come out of the courts. What do you think you're doing? And I would hate to see us have a prolonged, 3 to 7 year litigation period of that kind of back and forth when the country needs to invest in broadband.
So we're all lawyers here. Kevin has the particular distinction of having gone to Harvard with Barack Obama. So my colleagues here can take this way down the lawyerly road. But what I want to focus on is what Michael just said about the substance. I think everybody involved in these discussions agrees, meaning the carriers, the content companies, I hope most of the former chairmen, pretty much everybody at the FCC, they all agree to the following, I think. First, every single person who connects to the public internet ought to have a right to publish on that public internet. Not counting salacious, obscene material, not counting criminal activity, but in the zone of lawful speech, every single person ought to have a right to publish. It's a very big deal. It's sometimes called the non-discrimination principle. It is a notion of a fundamental freedom. It should not be unique to the United States. It ought to be the rule for the public internet everywhere in the world. It is not in most countries. We should not hesitate to enshrine it as essential to our idea of the public internet forever. Number two, we ought to have universal service apply to broadband and not to voice. If we're going to have universal service, and some people might say we don't need it, but as long as we're going to have it, as long as we're going to take from some people who are a little more wealthy and give to others in order to connect them to the public internet, it ought to be about broadband. It should not be about a voice. Everybody agrees about that, I think. Number three, everyone agrees that in order for everyone in America to be able to get connected, there ought to be an affordable price. There ought to be kind of a baseline service, a vanilla grade service that everybody can subscribe to, whether it is 1 megabit or 750 kilobits or 1.25. We should let the FCC worry about the details, but I think everyone agrees about that. And last, everyone agrees, I think, that after there's this vanilla baseline offering to everyone, if any single person wants to buy higher speed, if they want to buy vanilla with also chocolate ice cream and sprinkles on top, if they want to buy higher speed or managed service, they should have to go into the market and pay whatever they can get in a competitive market. The FCC should not tariff that. It should not rate regulate. It should not think that there's a need to intrude on the market. These are the basics. I don't think there's a debate about these issues of any consequence. I think that all the discussion is about, what if something much more dramatic were to occur? And that isn't a tempest in a teapot, that's a hurricane in a thimble, because nobody is suggesting anything beyond what I've just said.
I think the one thing I might challenge is that, and I wish it were true, that last one about the chocolate chip ice cream.
Tiered pricing. That's what I'm talking
I think there's
about.
a community of net neutrality proponents who roundly reject even that the economic efficiencies associated with tiering pricing, which, by the way, we do in every facet of our economy. A power user pays more than a basic user. That you should differentiate price as a consequence of consumption and cost causing, right? To sound geeky and economic. But I think that's part of what pollutes the net neutrality debate. There is a particular purist view about net neutrality that is, nope, it's lowest common denominator for everybody, no distinctions for anybody, no pricing differential for anybody, no fast lanes, no slow lanes, no tiering. And what's really interesting about that, because groups who honestly commit themselves to representing consumers are really arguing that only consumers should pay those prices. Because if at the end of the day there are costs, and there are real costs associated with a network, what you're really saying in that pure net neutrality view is If there are increased costs by power users, only consumers should be required to pay them. Google or any wholesale provider should never be part of the cost recovery mechanism. Now, what I find interesting about that is take wireless. We do exactly the opposite. If you are a lower economic demographic, you can still be in the cellular revolution because you can go get a phone for $25. Why can you go into a Verizon store and get a phone for $25? Because Motorola and Nokia are asked to pay and subsidize part of the expense so that people who can afford less can have it. Now, under a pure net neutrality view, you might say, oh, no, you're not allowed to charge Motorola or Nokia or somebody to help offset that cost. So the phone has to be at cost, which means every consumer has to buy a $500 phone. And I'm not so, the interesting thing is that's perceived as the pro-consumer view. And my concern is it's actually not the pro-consumer view. It's the pro-view of powerful internet companies.
Do you want to?
Yeah, I think that one of the things even this debate demonstrates is, while the highest level principles I think are generally agreed to, when you talk about how you put them into effect and when you talk about the means by which you can do that is where the debate begins to break down. And I think it's one of the reasons why the Commission should be very thoughtful and as they're approaching this issue to make sure that there aren't any unintended consequences, because some of the implications from something this is broad as like the reclassification go far beyond this debate and would have significant implications for future investment and future competition. And I think it's something that's why they should be very hesitant before they embark on that kind of a path.
You're watching C-SPAN's Communicators program. We're pleased to welcome three former chairmen of the FCC to our table today, and that's Michael Powell, who served under George W. Bush from 2001 to 2005, Reed Hundt, who served under President Clinton 1993 to 1997, and Kevin Martin, 2005 to 2009. He was chairman of the FCC under President George W. Bush. Amy Schatz of the Wall Street Journal, next question.
So I wondered if we could talk a little bit about indecency, which is something that at one point all of you have dealt with during your chairmanship. The FCC hasn't really done a lot of indecency enforcement in the last few years because of court challenges by the broadcasters. And I wondered, Kevin Martin, if you could talk a little bit about whether you regret in any way sort of pushing forward so heavily on indecency enforcement, which sort of prompted the broadcasters to sort of challenge the FCC's authority on this.
Oh, I think that when I was there, and I think when all of us were there, I think the obligations to just try to move forward and enforce the law that's written, I think is one of the obligations you have at the Commission. And I think that they're continuing to. I mean, one of the things, again, I guess that's striking about it is even the current Commission, has continued to appeal those decisions. But I don't think that the agency should either be afraid of ultimately the way that the court may rule one way or another. Actually, additional clarification on what the extent of the Commission's authority is a good thing, only so that it will help the Commission in how to respond to the many complaints that they end up getting.
Mm-hmm. Let's work our way back chronologically on indecency.
Yeah, Kevin makes a good point. It doesn't matter whether you like this portfolio or not. It's a statutory obligation. It may date back to 1927, but it's on the books. And the United States Congress has told the Federal Communications Commission, whether you like it or not, that's part of your job. The problem is the job proves heinously difficult to do because it's fraught with ambiguity and subjective choices and trying to maintain consistency of decisions across ever-changing content. I don't know about them, but I never found it a particularly enjoyable part of the job in any way, shape, or form.
Can I ask you a question?
I don't think anybody ever did.
But
can I ask you a question?
Yeah.
I've always wanted to ask this question. Were you watching the Super Bowl
Yes.
at the moment that Justin
Absolutely
Timberlake
was.
removed the ornament from the bustier? Is that what it is?
I was
The
sitting on a
ornament
couch in a neighbor's
from the
house.
bustier of
Yes.
Janet. You were watching.
I was watching
I was
live.
not.
You were not watching because you knew it would be indecent.
No, I got up during the
You
halftime,
knew
was
it would be
wandering around.
indecent.
I wasn't
But you were
watching the halftime
watching,
show.
and when it happened, here's my question. And when it happened, did you immediately say, I'm going to find these people?
This is exactly what happened. I was sitting at a neighbor's party on a couch watching the halftime show, and first of all, it sort of jumped out at me that, wow, this is a little racier than usual, because the dance is pretty wild as it was, and so I was watching, and all of a sudden I saw it, and I turned to my neighbor and I said, did you just see what I just saw, or am I dreaming? He goes, I think so. And we still weren't sure. And I went home and fired up my TiVo and started rewinding and realized, oh my God. And then the news started going, and I just said to turned to my wife, and I said, tomorrow's going to really suck. And it did. And you knew you had to sort of do everything you could to get up and ahead of that issue as fast as you could, just so it didn't completely spin off the rails. I mean, 550,000.
But you did become the only FCC chairman in history who was on Monday Night Football.
I did.
Talk about
did.
that.
Although I haven't been in a Janet video yet, which I was hoping to get.
There's still time.
There's still time. One last thing, though, about the indecency thing, and I think Kevin obliquely touched on it, too. The real problem here is the way the Supreme Court interprets the Constitution, which creates the difficulty. The Supreme Court said, dating back a long time ago, that somehow broadcast is different, that somehow these things the government can enforce without First Amendment implications, or certainly on a lesser standard, the kind of content that goes on broadcast TV. But to get back to my point about my children, I think this is becoming an increasingly untenuous distinction. Because if you look through the eyes and ears of consumers, there aren't any of these distinctions of any meaning anymore. Over 94% of Americans subscribe to cable or broadcast, or DirecTV or Dish TV platforms. The internet is a different The idea that we have different First Amendments for each of those medium, depending on how they're used, and the notion that my children are uniquely subject to broadcast when mine can pop open an iPhone and be watching YouTube videos in a second, I just think is untenable. And I think, frankly, I'll be even more direct and say, I think the Supreme Court has been irresponsible in not taking a case that would help the Commission and the government understand what the proper parameters of the First Amendment are in the modern context, and not vague references back to the 60s, the way TV was, 40 or 50 years ago. It's just not helpful, and I don't know about them, but to me, I found that made my job very, very difficult.
Kevin Martin, do you agree about broadcasters being treated differently, and is it time to end that?
Oh, I think that the challenge for broadcasters in today's multi-channel world and the disadvantage that they're placed in, I think that is a problem. I do think it'd be helpful if the court clarified it, but I also think that we need to make sure that there are ways that parents can protect their children from programming that they think is unsuitable. So I think that there need to be some additional tools at times for parents to be able to have more control over the content coming into their homes.
Such as?
Oh, well, listen, this opens up all the kinds of issues that we ended up debating, but I think that consumers should have more control both over the content coming in and how much they're paying for it. I think they should be able to pick and choose different channels that they want, and I think that the Commission should be concerned about some of the extension of that kind of cable monopoly model over to the internet and the delivery of video content. So I think those are some issues that I think that they should be concerned about.
Same question.
So I think my Republican friends are saying that broadcasters ought to be able to broadcast content that is as prurient and salacious as Mad Men or Entourage or any HBO series. And I just wondered if you've pre-cleared that with the Tea Party movement. Have you guys, have you run that by the censorship panel over there?
I would run it by anybody. I don't think the United States Constitution lives above any and all political conversation. It lives above, any one group's preference for how it should be. The problem here is not how far the rule is. The problem here is...
You've said this for 20 straight years, and you worked in the Clinton administration, and you've been very, very clear. You've been a First Amendment, almost an absolutist for 20 years, at least.
I think so.
But Chairman Hundt, what was your answer to the question about the broadcasters being treated differently than
So I had
others?
to answer it in real time, as my friends did. When I got there was a $1 million fine pending against Howard Stern. Now, given my age, you'll understand that was in the radio era. But there was a $1 million fine, and so I called up Mel Karmazin, who was running the business that that Howard was in, and I said, Mel, you and I can't have a productive conversation during my time as the FCC chair if you're not going to pay this fine, because as far as I'm concerned, you're basically a scofflaw. So we had this very, very direct, very pleasant conversation, and I thought it was absolutely clear that Mel had agreed, yes, I want to be a good citizen, we're going to pay the fine. He walked right out and they appealed it, and we never had a productive conversation because it was nothing but hammer and tongs in court, as Michael was saying, and there was a reason. Howard Stern thought it was much more fun to go on the radio and say things like FCC chairs ought to get cancer and die, which he did say, and much more fun to have his extremely jacked up audience get even more jacked up about the whole idea that there was this terrible, federal government that was going to deny them the right to, hear sexual innuendo, on the radio. That was much more fun than actually being part of a sensible culture that in which reasonable people could discuss things, and in which if you turned on the radio, you might not be assaulted by all kinds of fleeting expletives. So what you have here is there is always a on the margin slice of the content industry that wants to push the boundaries, not because they're First Amendment absolutists, but because there's a commercial opportunity from being the guy that's running the dirty bookstore, down the road. What do you do about that? It's really important to for FCC chairs, I found, to be talking to the industry, not in backroom deals, but in public. What do you all think are the right mores? Not saying the government is going to regulate you, but how do we establish some way for the culture to go forward so that we are not always dragged down to the lowest common denominator? I think it's a cultural question. And Kevin, you were saying that there ought to be more controls. That's the kind of thing that you do when you're having those conversations. I'm not talking about secret deals. I'm saying it's a healthy thing for our country to talk about our culture and what's coming of it, because I don't think that the trends are particularly great right now.
I was going to add only two other points. One is that I think that that just as there are certain obligations that we've been talking about get placed on broadcast because they're unique, they have certain benefits that they get as a result of that as well. One of the things that the current chairman started a debate about is should we be using some of that broadcast spectrum for wireless mobility, and is there a way to try to reclaim that and moving the broadcasters over? And so I think that there's another part of that debate as well. And when you're talking about the broadcasting that goes along with this, and I think that we need to talk about that because to the extent that they have certain benefits, then those do go hand in hand with certain kind of obligations. And I think that then under the current law, then you have to make sure that their benefits are protected, but so are their obligations. And that's one of the reasons why I think all of us, when we were there, enforced the law as is, and we're ready to do that in terms of indecency fines. But then the final thing I'd say is it's also much easier from the vantage point here of trying to have to this than it is when you're facing the pressures when you were making those decisions. And I think any of the commissioners would end up saying that. The chairman would say that as well.
Well, Kevin Martin, one of the broadcast companies, NBCU, is looking at a merger with Comcast, and it's at this point likely to go through, I guess it's fair to say. But you've surprised a lot of people in the telecommunications world with your opposition to that merger. Could you explain why? And we'd like to hear then from the other two on their position on this merger.
Well, I think that certainly the merger raises certain kind of concerns for the implications, as any merger does for some of their competitors, and the power that a cable operator might end up having to favor certain kinds of content over others. Certainly, for example, I think that the public interest certainly has a critical importance as it relates to news, making sure that independent news operators continue to be able to operate. And the fact that you then have a cable operator, the largest cable operator in the country, that would also be owning one of the competitors in the business news space, for example, I think certainly raises concerns for their competitors in that sense, and that they could be discriminated against. And I think that that's things that the Commission typically takes into account when you're talking about a merger one way or another.
Chairman Hundt?
Well, I was an antitrust lawyer for nearly 20 years before I got to the FCC, so I guess I'm old school on this. Vertical mergers don't pose the kinds of risks to competition that can be presented in some horizontal mergers. This is a vertical merger. I've never thought that it raised any serious issues, and frankly, I haven't seen anyone in public office in the last year say that there were any serious issues.
I'm sorry, when SBC talked about purchasing AT&T, I think that was described as a vertical merger that at the time you said was unthinkable.
Actually, I'm so glad you raised that. It was described that way by people who wanted to get into the safe harbor of vertical mergers, but at my very poorly read but well-delivered speech at Brookings, I explained all the horizontal dimensions of that merger, and I did the best I could, and it was the horizontal dimensions that were the reasons why I said that it was unthinkable. In fact, it was the horizontal competition, long distance into local, so that there would be competitors in local. That was the whole reason for the Telecom Act. It wasn't to vertically integrate that anybody wanted that. It was to have it be that there would be competition in long distance and competition in local. So when you look at this merger, this isn't about cable and telco merging in the same market, that would be a horizontal issue.
I think this raises a really interesting issue because we're talking about having Comcast buy NBC, and it's very likely that the FCC will agree to that. But at the same time, if a local TV station wanted to buy a newspaper, they probably couldn't. Do you think that today's media ownership rules still make any sense given the current environment, which
No.
most people watch
They don't-
TV
they don't.
or listen?
Excuse me for interrupting, but isn't no our answer?
You know,
Since
I-
every
I
one
said-
of us
I said-
tried to change them?
I said no 6 years ago, and
Exactly.
they almost took my head off. There's no more. I don't know if my two friends will agree, but in my view, if you looked at every sector of communication regulation, there is no more incoherent collection of rules than the media ownership rules. They are rooted in a market that is decades gone. They are completely drafted exclusively for broadcasting, ignoring willfully the arrival of competitive alternatives outside the broadcasting environment. I think the average consumer does not understand that these rules don't even take into account whether cable exists. They don't even take into account whether the internet exists. They don't take into account whether satellite television exists. They act as if broadcasting lives in a market completely unto itself, insulated completely from all of these historical developments. Now, maybe they made sense 50 years ago when there was no cable industry, or no satellite television industry, or no internet, or no VCR, or no DVDs. But all I've ever argued for on this is, look, we can have a debate on how the rules should come out, but the notion of us willfully ignoring genuine, legitimate developments in the marketplace only so that we can have a special playground where those who sort of hate the media can argue ferociously for them, they're taking over the world and we're going to get them as long as we get them only in this tiny little space, I just think is intellectually dishonest on the part of the federal government.
But look, let's the three of us tell Amy the truth about why not any one of us got rid of the newspaper broadcast cross-ownership barriers. Why didn't we do it?
I was going to say, I think that we all tried, and certainly I think.
Well, why didn't we succeed?
Well, actually, I think that one thing I would point out is that the commission's rules that we adopted when I was chairman actually did go into effect, and actually the current administration is defending those, which eliminated the absolute prohibition. Now, it may not have gone as far as we had tried to do originally.
Why didn't we get the eraser and just get rid of them? None of us thought the rules made sense.
It's a simple reason. It's politics.
That's the reason.
It's all about, one of the things
That's
that I was
the
taught.
only reason that none of us got rid of them.
One of the things that I was taught when I was learning this stuff is remember one thing. These other industries are of mild interest to the Congress. Media is their lifeblood. And one of the things that, if I were being completely frank, what you run into is, let me tell you, if you run for office in Texas and you're mad at the Dallas Morning News because they're editorializing against you, it'll be over your dead body they get to buy a television station. This market is completely corrupted by the political calculations that go on and are associated with what the outputs of transactions would be. And I guarantee you, every one of us has at some point had a surreal conversation with a congressman about one of these rules, and the only way you could make sense of it was, if it were liberals, I'll be damned if the Fox network is going to gain one more ounce of authority. And if it's conservatives, they're no more pure when it comes to certain newspapers and certain combinations, and you're like, wow, that's what this is ultimately really about. And I think that's what it really is.
I was just going to say, see, I think that the most interesting aspect of this, talking about the politics versus the substance, is when I was chairman, then Senator Barack Obama wrote and objected to the removal of the broadcast newspaper cross-ownership rule and objected to the rules that I put in place. And then Currently, the administration is actually defending those rules in court, saying that they were appropriate for the commission to adopt.
But the real political question, if I may be so bold, is the Citizens United case and the effect that that's had on advertising in this election. And the FCC, I would assert, does have the following regulatory power. It can require that broadcasters not run any political advertisements unless those advertisements reveal where the money is really coming from.
Do you think they need to do more of that?
It can do what I just said, and it doesn't do it. And Congress can do it too. And I think the American people, when they're hit with a deluge of advertising from corporations that were invented yesterday and are funded by who knows whom, and they all have a right to know where the money is really coming from. And it's a disclosure rule, which I think everyone would agree the FCC could adopt or Congress could pass in a statute. But I think for the American people not to know where these opinions are coming from. They're certainly not facts that are in these ads. So where are these opinions coming from? For the American people not to know, it's a kind of fundamental spuriousness of speech that is not helpful to our democracy.
This is the C-SPAN's Communicators program. We have about 10 minutes left with our three special guests, three former chairmen of the Federal Communications Commission. Michael Powell, 2001 to 2005, he served as chairman. Reed Hundt, 1993 to 1997, and Kevin Martin, 2001 to 2005. Amy Schatz with the Wall Street Journal is our guest reporter.
Thanks very much. So all of you have been in this chair that Julius Janikowski's in now, and he's dealing with a lot of issues, whether it's media ownership and decency or net neutrality. Do you have any advice for him on how to handle this? He's getting attacked on all sides at this point.
We're smiling because we're grateful we're not sitting there.
You know, I think that probably some of the most important advice that I got when I was chairman was that you had to be deliberate in your thinking and in your decision making, but that you needed to make sure you move forward with what you thought was the right thing to end up doing, irrespective of the noise that was created on either the left or the right around you. And actually, Reed was the one who gave me that advice when I became chairman, and I thought that was probably one of the most important pieces of advice that I got.
I think one of the things that you hope and pray when you take that seat, which ultimately proves futile, is that somehow through your gifts you're going to constantly bring a collective consensus around difficult issues, and you're going to lead, you know, a group happily to the right result. The reality is this is an intensely fought industry with billion-dollar players on every conceivable side. By the way, even interest groups who often are funded at significant levels to fight these battles. You shouldn't, you know, it's not a job you can have if you're looking for universal acclaim on anything. It just isn't going to lend itself. I do think what you have to do, kind of what Kevin says, is you've got to telegraph very clearly what your core principles are, what you believe in, what you're going to stand for, and you most importantly have to act consistent with them in a somewhat predictable way. You know, people used to be able to say, you know, you're never going to get Powell to do that, right? I mean, they may be mad about that, but there was a certain certainty that went with trying to telegraph this is what you stand for, this is what you don't. But the more important part of that is you have to invest your capital and take the risks. You can't, there is no solution where people will bring you the right things. You're going to have to go out there and get dirty. You're going to have to go out there and say, you know, try to be a central player in the outcomes of those things. I mean, I think net neutrality is a good situation. You know, the chairman has a very tough problem on his hands. But my advice to him would be, you have a very powerful bully pulpit. Your soft power may be more significant than your formal power, and we need to see you. We need to see you go out there and invest yourself and make clear to all the players what are your bottom lines, what are the kinds of things that you'll accept and you'll not accept, and really help drive, you know, this crazy plane and get it landed. I don't think that you can hope it gets resolved on his own, and I think he certainly is weighing those kinds of things, but I've seen each one of these guys have an issue or two where that's what they had to do. They had to go out and really put themselves out there and take those risks and try to drive a solution. And sometimes it works out, sometimes it doesn't. But you can't effectively do the job. And last thing I would say, and I think Kevin said it, is you have to believe you're a manager of the agency too. It's an institution. It has to get its work done. And, all of us at times have had to go through that circulation. Look, we're not getting stuff. You guys got 1 week to get this out of here. The place has got to keep moving or it drowns. It drowns in the volume that comes in. And I think any chairman has to also commit to being an aggressive manager.
I think Julius Genachowski has done a great job. The FCC chair, in a sense, is the steward of the information and communications technology sector of the economy. He doesn't control it. He doesn't regulate all of it. He or she doesn't want to regulate all of it. But in some sense, he's the steward of it. It is important that he not break it. And if there are problems in the sector, they need to be fixed. When the Obama administration came in, we were in the middle of the worst recession since the Great Depression. We've had the inevitable and tragic corollary, which is millions and millions of people have lost their jobs. Construction sector unemployment is well more than 20%. What have we seen in information communications and technology? We've seen the tech companies come back faster than any other companies. We've seen continued capital expenditure. We've seen the wireless companies move into 4G, all this in just the last 20 months. We've seen tremendous growth of social networking on a platform of constantly upgraded broadband. We have, relative to every other sector, a much brighter story. Is it as good as it will be? No, but in the next 2 years, we will see, between now and when the president runs for re-election, we will see still more growth, still more productivity gains, still more technological advances in the ICT sector. This is the #1 test, whether things are heading in the right direction in terms of employment and in terms of investment, and they are. #2, Julius Genachowski has changed the conversation. It is now widely accepted that universal service ought to be about broadband. It was never that way before. Michael and I used to argue about that 10 years ago, but now everyone agrees about that. It's widely accepted we need more spectrum in commercial hands. Everyone agrees about that. It's widely understood that we need to have the United States be a leader in advocating for internet freedom and market access for public internet in every country in the world. All of these topics are topics that Julius is either the primary author or one of the principal spokesperson, and he's a leader in all of these respects and others.
Reed Hundt, how involved was Bill Clinton in the FCC and decision-making? Did you feel that you had leadership from the White House, input from the White House, interest from the White House?
Bill Clinton, I once was in the Oval Office, and he told me that he thought that I had a nice tie, but that I needed to stand up straighter for the photo. I went to law school with him. He's a brilliant guy, but this particular sector, he repeatedly said that he trusted Al Gore to give the guidance on behalf of the White House, and Al Gore did that. And I was in many, many meetings with Al, and all of you have met Al over time as well. I was in many, many meetings with Al. The very first thing he said to me was this. It actually was two things. When Al called to say that the president was going to appoint me, I said, "I'm incredibly grateful." He said, "This is literally what he said." He said, "Don't be grateful. Just do the best you possibly can do." And then the second thing he said is, "There is one thing I want you to try to accomplish. I would like to see the internet connect every single child in every classroom in America to the Library of Congress." In fact, years later, thanks to the critical vote of Olympia Snow and the leadership of Jay Rockefeller, the E-rate program, which my colleagues here also supported and administered, the E-rate program did in fact produce the connectivity. Something like 90% of all the classrooms of the United States, 95% of all the libraries, in fact, do connect not just to the Library of Congress, but to all other data sources in the world. We're the only country in the world that has had the internet move into the education sector at the same rate for poor kids as for rich kids. That came out of Al Gore's vision.
George W. Bush, his involvement to both of you. We'll start with Michael Powell.
I would personally relatively modest. I think there was a similar perception that we appoint quality people who have the expertise and the foresight to run that agenda. And I think people should understand you're not a cabinet officer. You are not part of the administration. And in fact, there are even ethical limits to the interactions between a White House and an independent agency. So every president, every White House has the same issue. I think the public assumes there's this never-ending dialogue going on back and forth. Point of fact is there almost rarely is that kind of continuous involvement, because there are limits to the amount of that as a consequence of what kind of agency you are. In the old days, I haven't seen it lately, but Congress used to be vicious about attacking the commission if it perceived it was in direct coordination with White Houses about policy. So you should know that by design, it's not supposed to be all that much. The other thing is I happened to be sitting in the seat when those planes hit the towers in New York, and I think the world changed forever. And understandably, you had a White House that had to turn every ounce of its attention to the protection of the American people from the consequences of terrorism. And by the way, it had a huge effect of even what we had to focus on at the commission. Suddenly I was on a train in New York trying to figure out how we were going to restore the nation's biggest central office, how I spent days with communications experts on how to get the Wall Street market back online. These were scary, scary days. And while now we're still talking about the esoterics of telecommunication policy, for that period and for years to come, and particularly when the country went to war as a consequence of these activities, that was what government was centrally focused on. And so in some ways, I felt like not only did I have responsibilities with respect to stuff, and by the way, I remember the day, 3 days after it happened, my phone rang and it was Reed. And Reed said, "Mr. Chairman, this is crazy. This is the most seminal moment for the country. Get on a train and get up there. You should be part of this." And I followed his advice and did that thing. The other thing, though, I think that happened was the president turned to a lot of people in government and said, "We're consumed. I expect you to take care of your sector, your sector, and you're going to have to do it in a way that gives us comfort that the rest of the government's running effectively without our direct involvement."
No, I mean, I think that's right. I think that the White House is actually, I think, typically only modestly involved in the decisions that are going on at the commission. Congress is actually much more involved in trying to influence the decisions than the administration usually is.
So you all have been out of the chair for a couple years now. When you look back on your chairmanship, what was the one that got away? Which is the one thing that you wish that you could have gotten past while you were there?
Gotten past. Well, I'm the one that's been away the longest, so I've been brooding for the longest period of time. The decisions that I made around a certain block of spectrum produced the biggest bankruptcy in American history, and the most famous bankruptcy decision ever decided by the Supreme Court. And I should have settled that case. And we had the settlement, and I didn't. I wasn't persuasive enough with my fellow commissioners. So
What was the case?
Next Wave.
Next Wave.
So that was clearly the biggest decision that I failed to make, the biggest one that got away.
And what do you think the result would have been had you been able to persuade your fellow commissioners?
Well, Next Wave was trying to build a national wholesale network, a topic that now has continued for all the years since then and is still the holy grail of certain kinds of entrepreneurial investors. There's a business right now that is trying to do that. So it might have been that more than a decade ago that particular business model would have come into existence.
I think my greatest regret is all around the media ownership stuff. And not just because it was probably the most controversial thing I was involved in. I just deeply felt it was embarrassingly incoherent. I deeply felt it was going to distort the ability of premium content to move to digital platforms more effectively because of the distortion of the rules. And I learned a lot about tactics. I mean, I think we made a lot of mistakes in the way we attempted to get it done, but I have never wavered in my belief that we were doing the right thing. And I've never wavered in my belief that ultimately time will prove that that's where we had to go as a country. And so I really regret that we didn't make better progress. We did get the rules done, but they stayed in court, and that has proven to be 7-8 years of stasis. This is what happens when things, end up falling all over into the court, and all of a sudden you have these rules haven't been particularly modified. Kevin did a piece, but we continue to have this thing in limbo. I would have preferred if we could have found greater collective consensus to do some things that would have put this on a better track, because today, whether it's Hulu or anything else, these things are still having major effects on whether we can get to the world that consumers really want. And part of it is because we're still so broadcast-centric in the policy.
Kevin Martin.
I think that the one that got away, or the vote that we wasn't able to bring to conclusion with the other commissioners, was when we tried to reform universal service at the end of my tenure. I mean, I think that there was a recognition by everyone of trying to move universal service into a broadband world, where we begin the process of eliminating the archaic rules surrounding it and making sure that everyone is connected to broadband. And that was a proposal I put forth at the end, but that I wasn't able to get the commissioners to move forward on. I think that as far as that was the vote that was put forth, I still think that the issue that I think that needs to have more attention focused on is I wish we could have done more for consumers in terms of their video choices and their video prices. Cable rates have doubled during the last decade. They've gone up more than that if you look at it compared to the '92 Cable Act, when they deregulated. When they re-regulated cable rates, and then they were deregulated in '96. I think that's a real problem for most consumers. They're having to pay an increasing amount for a larger and larger bundle that they're not satisfied with. I think that wasn't anything I ever put to a vote. One of the misperceptions was I never said that the commission had any authority of anything we could do with that. I just thought that was an issue that we should talk about, because I think it was a problem for most consumers, and I think more needs to be done on both those.
And so on the flip side of that question, we'll start with you, Chairman Martin. What's your legacy? What are you most proud of?
I think that the auction that we conducted, in which we both raised significantly, wireless auction that we conducted, we raised more revenue than had ever been raised in any other auction, and we were able to put in place certain kind of rules that I think helped open up the market in terms of changing the wireless industry's perception of being more open to different devices and applications was a critical change in both the terms of getting additional spectrum out into the marketplace, and in changing some way the way wireless was perceived as going to be a kind of a next generation broadband, the ability for people to connect to broadband in a next generation way. And I think that was the most significant thing that I was able to do.
Mr. Powell?
Well, during my tenure, I was faced with the internet really began to be clearly emerging as a central communication platform, and I think we worked very, very hard to reorient the agency toward an innovative broadband bit-as-a-bit focus across everything we did. Most of our initiatives in telecom policy, wireless, on the consumer side, involved focusing on trying to reorient the agency to where the world was going rather than looking rearward to where it had been. I think we made some good progress on that. I'm very proud of some internal things we did. During my tenure, we created the Fcc University, which was an academic program to keep staff current on changing technology, which continues to run today. On television front, last two things, the DTV transition was completely stalled. I was very proud of the voluntary plan we put together that helped get that moving and ultimately led to the return of spectrum and the ending of that transition. Although my neighbors will tell me the only thing I did worth a damn is the do not call database that allowed people to get, people to stop calling them at dinner time for services.
And finally.
I have three things I want to say, but first I want to say this. I bet I speak for my friends here and for other people who've held our job. What a privilege it was to be the chair of the FCC. Not only is this a great country, that's a great job in government, because you really have so many things that you can do to try to help the country move along into the future. And so when we look back at it, I know we all feel that way, right? I mean, what a lucky break to get that job. What are the three things? The internet as a commercial phenomenon emerged pretty much the same month that I got confirmed. That's a coincidence. And the way that it emerged was in what was called narrowband. Narrowband, the father of the broadband that emerged when Michael was the chair. We, and when I say we, these were decisions that were made unanimously, meaning Republicans and Democrats on the commission voted the same way on the things I'm talking about now. We made the decision to have the internet in its salad days just absolutely explode. The technology is what made that possible, but when we said that you could take the telephone line out of your telephone and connect it to the back of your computer and not pay any more to get on the internet. It was a critical opening of a door to hypergrowth and launched the internet age in which the United States was and still is the global leader. We didn't know it would be quite as great as it turned out to be, and we made a whole bunch of other decisions that were supportive, but it was the right direction, and I think you guys would agree. You just try to get the direction right. You're never going to get all the details right. That's direction number one. Direction number two, when Congress gave us the auction authority collectively at the FCC, we decided to use auctions to create a robustly competitive wireless market. That's what the auctions did. They did raise a lot of money, but they created a robustly competitive wireless market, and my colleagues maintained a robustly competitive wireless market. And it's because it's robustly competitive that it is the least regulated of all the communications media in the history of the United States, that's not a coincidence. That has translated to a more rapid pace of innovation and development and investment and job growth. Third and last, I was part of the team that negotiated the 1997 telecom treaty that in fact established in 69 countries independent regulators that would try to have the authority and the vision to build a global communications network that linked everyone in the world. We need to upgrade that into a broadband treaty, but it's the right way to go because it breaks down barriers among countries and it lets us compete commercially and not in the military way, and it's the right vision for the future.
And finally, gentlemen, what are you doing today, and are you working with telecommunications clients or in telecommunications issues? Reed Hundt.
Well, my children ask me what I'm doing too. Tonight I'm flying with my wife to Paris to celebrate our 30th wedding anniversary. But you'll often find me in Silicon Valley where I'm on the board of several tech companies.
Kevin Martin.
I'm a partner at Patton Boggs, and I also do serve on a couple boards of several different equipment companies, and so work with a variety of telecommunications, technology, and media companies.
Michael Powell.
I'm a partner for the private equity firm Providence Equity Partners that focuses only on telecom, media, and technology, so it's all the stuff that I love, and I'm also serve on the board of Cisco and AOL.
Gentlemen, thank you for being on the Communicators. We've gone past our allotted time. We appreciate this, and I hope we can get the three of you back at some point for a further conversation. Amy Schatz, as always, with the Wall Street Journal. Thank you for being our guest reporter. This has been the Communicators. Thanks for joining us.
Thank you.